Welcome to PATRIOTS IAS Academy. If you are new to our channel, please subscribe. Indian Judiciary. The judiciary is that branch of the government that interprets the law, settles disputes, and administers justice to all citizens. The judiciary is the branch of the government that interprets the law, settles disputes, administers justice to all citizens. The judiciary is considered the watchdog of democracy and also the guardian of the constitution. For a democracy to function effectively, it is imperative to have an impartial and independent judiciary. So, the judiciary is a branch of the government that interprets the law, settles disputes, administers justice to all citizens. It is the watchdog of democracy. It is the guardian of the constitution. For a democracy to function effectively, it is imperative to have an impartial and independent judiciary. Independent Indian judiciary. It means that other branches of the government, namely executive and judiciary, does not interfere with the judiciary's functioning. Legislative and executive does not interfere the functioning of the judiciary. Judicious decision is respected and not interfered by other organs. It also means that judges can perform their duties without any fear or favor. In the independent Indian judiciary, the judges can perform their duties without any fear or favor. Independence of judiciary also does not mean that the judiciary functions arbitrarily and without any accountability. The judiciary is accountable. The judiciary is accountable to the Constitution of India. The judiciary is accountable to the Constitution of India. How Indian judiciary is granted its independence. The Constitution provides for a number of provisions that ensure that the independence of judiciary is maintained and protected. The separation of judiciary from the executive. The directive principles of state policy says that the state shall take steps to separate the judiciary from the executive in the public service of the state. According to the Article 50, there shall be a separate judicial service free from executive control. The Article 50, very important. It can also ask in the prelims. Article 50, there shall be a separate judicial service free from executive control. The Supreme Court has the power to punish any person for its contempt, as per Article 129. The Article 129 lays down that the Supreme Court shall be a court of record and shall have all the powers of such a court, including power to punish for contempt. So Article 129, very important. It can also ask in the prelims. Gives the power to punish for contempt. Indian judiciary structure. India has a single integrated judicial system. The judiciary in India has a pyramidal structure with the Supreme Court at the top. High courts are below the Supreme Court, and below them are the district and subordinate courts. The lower courts function under the direct superintendence of higher courts. This is the pyramidal structure. At the top, the Supreme Court of India. Its decisions are binding on all courts, can transfer judges of high courts, can move cases from any court to itself, can transfer cases from one high court to another. High court can hear appeals from lower courts, can issue writs for restoring fundamental rights, can deal with cases within the jurisdiction of the state, exercise superintendence and control over courts below it. District courts deals with cases arising in the district, consider appeals on decisions given by lower courts, decides cases involving serious criminal offences. Subordinate courts consider cases of civil and criminal nature. There shall be two branches of legal system, the criminal law, civil law. The criminal law deals with the committing of a crime by any citizen or entity. The criminal case starts when the local police file a crime report. The court finally decides on the matter. Civil law. The civil law deals with the disputes over the violation of the fundamental rights of the citizen. So there are two branches of legal system, criminal law and civil law. Supreme Court has three types of jurisdiction. They are original, appellate and advisory. The jurisdiction of Supreme Court is mentioned in the Article 131, 133, 136 and 143 of the Constitution. Functions of the Indian Judiciary. The Supreme Court of India, the guardian of the Indian Constitution. The highest court in India, the Supreme Court, acts as the guardian of the Constitution. The conflicts of jurisdiction between the central government and the state government or between the legislature and executive are decided by the court. The conflicts of the jurisdiction between the central government and the state governments or between the legislature and executive are decided by the court. Any law or executive order which violates any provision of the Constitution is declared unconstitutional or null and void by the judiciary. This is called judicial review. Very important. So what is judicial review? Any law or executive order which violates any provision of the Constitution is declared unconstitutional or null and void by the judiciary. This is called judicial review. A judicial review has the merit of guaranteeing the fundamental rights of individuals and ensuring a balance between union and the units of the federal system. The units and in a federal state. Right. Supreme Court, the protector of fundamental rights. The judiciary ensures that people's rights are not trampled upon by the state or any other agency. The superior courts enforce fundamental rights by issuing writs. The Supreme Court, the protector of fundamental rights. Advisory functions. The Supreme Court of India performs an advisory function as well. It can give advisory opinion on all constitutional questions. This is done in the absence of disputes and when the executive so desires. Right. The special role in a federation. The Supreme Court's special role in federation. In a federal system like India, the judiciary also performs an important task of settling disputes between center and states. It also acts as an arbiter of disputes between states. So, Supreme Court, protector of fundamental rights, it has an advisory function. It plays a special role in federation. Administration of justice, very important. The chief function of the judiciary is to apply the law to specific cases or in settling disputes. When a dispute is brought before the courts, it determines the facts involved through evidence presented by the contestants. The law then proceeds to decide what law is applicable to the case and applies it. If someone is found guilty of violating the law in the course of trial, the court will impose a penalty on the guilty person. Civil courts deal with civil cases. Civil law is referred to in almost all cases other than criminal cases. Criminal law applies when a crime such as robbery, murder, arson, etc. is perpetrated. Civil law is applied in disputes when one person sues another person or entity. The examples of civil cases are divorce, eviction, consumer problems, debt or bankruptcy, etc. Judges in civil courts and criminal courts have different power. So there is a power difference between the judges in civil courts and criminal courts. While judge in a criminal court can punish the convicted person by sending him or her to jail, a judge in civil court can make the guilty pay fines, etc. So these are about civil court, civil law and criminal law. This is the hierarchical system in the Indian judiciary. Supreme Court at the top, High Court, Metropolitan Courts, District and Session Courts. Try to go through all this. So these are all about the Indian judiciary. If you like the video, please subscribe our channel. Please share the video with your friends. Thanks for watching.